Hey everyone, welcome back to Girl Talk. Thank you so much for joining me. As always, before we get started, if you could give me a like, share, a thumbs up, comment, and hit that subscribe button, I would appreciate it. So today we're going to get into day 6 of the Lindsay Clancy trial, and we're just going to go over, it's about, I don't know, about a half hour, 45 minutes of the main topics that they touched on yesterday. I think that's a little bit easier than going through the complete testimony. But if we do find out that we're missing testimony, then we'll go back to doing that. So let's get into it, and here we go.
You are requesting or offering to stipulate to certain facts. Is that correct?
Yes, Your Honor.
All right. And before I accept that, I got to ask you some questions, make sure that your decision to do so is voluntary, that you understand the consequences. So I'm going to ask you some questions. If at any time you need to speak to Mr. Reddington, or you have any questions or have problems understanding what I'm saying, just let me know, okay? All right. Now, do you understand that the Commonwealth, in this case, is required to prove each and every element of the case against you beyond a reasonable doubt? Do you understand that?
Yes, Your Honor.
All right. You understand that there are certain facts that could be introduced during the course of the trial that would might support the Commonwealth's position regarding those elements. Do you understand that?
Yes, Your Honor.
All right. And you understand that by signing the stipulation, you agree that the Commonwealth does not have to prove these certain facts that are contained in the stipulation. Do you understand that?
Yes, Your Honor.
And do you understand by signing or going along with that stipulation, you are basically relieving the Commonwealth of its burden to prove those certain facts? Do you understand that?
Yes, Your Honor.
All right. Is that what you want to do at this point?
Yes.
All right. Have you gone over this stipulation or the summary of the stipulations with Attorney Reddington?
Yes, I have.
All right. Need any more time to do that?
No, thank you.
All right. Now, by entering into this stipulation, you're giving up some important rights. So I kind of want to go over those with you at this time. To understand, by law, you're presumed to be innocent of each charge against you, and you do not have to prove your innocence. All right. So instead, at trial, the Commonwealth, as I said to you before, has the burden of proving you are guilty of each element of the charges against you. By entering into this stipulation, you're giving up your right to force the Commonwealth to prove the facts that are contained in these stipulations. Do you understand that?
Yes, Your Honor.
All right. You also, at trial, where we are now, you have the right to confront the witnesses that would testify about these facts. And by entering into this stipulation, you're giving up that right with respect to these stipulated facts. Do you understand that?
Yes, Your Honor.
All right. You also, if you wanted to, could call your own witnesses at the trial to contest these stipulated facts if you wanted to. You understand you'd be giving up that right by entering into this stipulation.
Yes, Your Honor.
All right. You also, at trial, have the right to remain silent and cannot be forced to testify at this. You understand, by entering into this stipulation, you're giving up in a limited way that right with respect to just those facts.
Yes, Your Honor.
All right. Are you doing this willingly and voluntarily?
Yes, I am.
All right. Has anyone forced you or threatened you to enter into this stipulation?
No, Your Honor.
Have you had enough time to talk to counsel about this?
Yes, I have.
All right. All right. I make the following findings. I find that Ms. Clancy has knowingly, intelligently, voluntarily, and willingly entered into the stipulation of the facts that are contained and summarized in Exhibit J for identification. I find that she is competent to enter into this stipulation. I find she understands the consequences of entering into this stipulation. So accordingly, I now accept the proposed stipulation of facts.
Now, we will see if that actually changes anything, the flow of the trial, if it's going to speed up or not. We'll see. We'll see as it goes. Remember, Lindsay Clancy's not arguing that she killed the kids. She agrees she killed the kids. She's arguing that she was insane, that she was not in the right frame of mind, that she was mentally insane, that she had postpartum psychosis, and because of that, she should not be held criminally responsible. So, top points from today. Oh, there's Everett. Top points from today. No drugs were found in the children's system after they did any of their systems after they did toxicology reports. I don't know if that was ever an issue where they said that the children had been drugged. Could have been possible that she did, but it sounds like she didn't. We'll get into that. The defense continues to point out missed evidence gathered by the police, and then we also learned about a blood stain analysis taken at the Clancy home. Okay, let's jump into it. Christina Carpio, ER surgeon, was the first witness on the stand today. She worked at South Shore Hospital. She was the surgeon who worked on Lindsay Clancy. It was quick testimony establishing the severity of Lindsay's injuries. They were so severe within hours of care at South Shore that Clancy had to be transferred to another hospital.
What was the ultimate recommendation for the care of this patient?
She had complex fractures in her spine at the thoracic level. We conferred with our neurosurgery colleague who was on call, who recommended transfer to a tertiary hospital.
And so where did this patient go?
Brigham.
And you reached the end of your rope. She had to be transferred because she needed immediate high-level medical care, right?
She needed higher level of care.
Higher level of care. And as a result, she was then brought to Brigham and Women's Hospital. Now, the treatment that you had given would include raising her, apparently, temperature. I guess, because she came in at a low temperature, right?
Yes.
And did you use IV fluids?
I would have to check the record, but that is a common intervention.
So, your memory would be that you believe that you used IV fluids, but you'd have to have me get out of the box and check the record to ask that question, right?
Yes, correct.
Okay. It didn't really work out very well, though, did it? Because you know that when she was brought to Boston, after all of the time that she was treated at your hospital, she was still core temperature of 82 when she hit Brigham and Women's.
Allow it if she knows.
I did not look at the medical record from another institution. I only reviewed my note from South Shore Hospital.
So she was transferred to the other hospital, and that was the end of that witness. Next up, we heard from Joseph Rabbit. He's from the State Police Detectives Unit. He was in charge of taking custody of a pill bag that was dropped off by Patrick Clancy after the deaths of the children. We've seen a lot of those pills. They've been brought up frequently throughout this trial. The Commonwealth went through each prescription bottle and cited how many pills were left in each bottle. Most of them that we saw the other day, at least, were full. Only a couple of pills had been taken out. It's not like there were a lot of empty bottles. The level of medications and the doses, of course, play a key role in determining Lindsay Clancy's mental state. After the prosecution, defense attorney Kevin Reddington once again pointed to missed evidence that was not gathered from the home, such as Lindsay's Apple Watch and an additional bag of pills that was in her bedroom dresser.
Referring first to this bottle that's labeled lorazepam, 1 milligram. Fair to say it says date filled 10/26/22, correct?
Correct.
And it says that originally it was filled with 30, quantity 30.
Correct.
And you counted what was left in this particular bottle, and there were only 14 pills left in that bottle, correct?
Correct.
And so the next one, bottle labeled sertraline, brand name Zoloft, filled on 9/15/22, quantity 30. Did you count how many pills were left in this bottle?
I did, yes.
And fair to say there's 23 left.
Correct.
Now, buspirone. There were, in fact, 2 bottles labeled buspirone, correct?
That is correct.
And one of them with a date of 10/26/22, date filled, quantity 30. You counted how many pills are in this bottle, right?
Correct.
And there were 28 pills left in this bottle.
That is correct.
Hydroxine, filled on 10/26/22, quantity 30. You counted how many pills were in this?
That is correct.
And fair to say there were 27 left in that bottle.
Correct.
Clonazepam, filled on 11/25/22 with 14 pills in the prescription. You counted how many were in this bottle?
Correct.
And there were actually 11 and a half, correct?
That is correct.
fluoxetine, filled on 11/21/22, with 56 in the prescription. You counted how many were left in this bottle,
I did, yes.
and there were 43.
Correct.
The second bottle of lorazepam that was 0.5 milligrams, filled on 11/2/22, with, it says 40 on the bottle, right?
Correct.
You counted what was left in this bottle, and it was 18 and a half tablets.
That is correct.
And the second bottle of buspirone, filled on 11/9/22, quantity 30. There were actually 30 in this bottle. Is that fair to say?
Correct, yes.
And trazodone, filled on November 16th, 2022, with a prescription for 30. You counted that there were 22.5 pills left in this bottle. Is that correct?
Correct.
And then once you identified and counted each and every one of the pills in these bottles, you handed this in for evidence.
That is correct.
Do you recall whether or not anybody in your presence or anybody went into a drawer, a nightstand, and looked in the drawer and saw an Apple Watch, a bunch of pills, things to use to assist your sleeping, things of that nature? Anybody doing that?
I can't. I don't know if anybody did or not.
There were 1, 2, 3, 4, 5 prescription bottles that were seized. Have you ever seen these?
I have not, no.
So you went through the pill count on the bottles for the district attorney, and you did that when you did inventory apparently of these pill bottles that you are talking about, right? For the DA, she asked you to look and tell us how many pills were missing, right?
I did that for the ones that were turned in.
Right. And nobody ever looked at these bottles, right?
I don't know if they have or not.
So why did I bring this up? Well, a lot of times the defense attorney will try to poke holes anytime they can into the police investigation. We saw that a lot with Corey Richins. You didn't gather this, you didn't gather that, you didn't gather this. It can make jurors start to question on how thorough of an investigation was done on this type of a case, this type of serious case. All right, we next heard from Maureen Harnett. She's a forensic scientist with the state police who examined the crime scene in the house and gathered blood samples. She also tested DNA samples from the exercise bands that were used to kill the children. And several months later, she went back to gather samples from the second-story window where Clancy jumped from. Here's a picture taken earlier this week of that second-story window. You can see it. This is Grace Wong, our producer, got these, and you can see just how far it is from the top of the home to the bottom, or from the top of the window to the bottom ground. Maureen Harnett testified about what she found there on the windowsill.
Why didn't you swap the whole thing?
The purpose of the collection was to potentially determine who was holding or had contact with the ends of the band and who potentially had contact with the center of the band, potentially those being two different individuals. So I collected samples separate from the ends as, in addition to the center.
And was your approach on each one of the bands the same?
Yes, it was.
So the second band, which is the black band that was identified as item 2-3, you took samples again from the ends in the middle?
That's correct.
And I'm just going to show you another photograph. And is that the black band you examined?
Yes, it is.
That may be admitted.
And finally, the blue exercise band that was recovered from the home at 47 Summer Street, that was identified as item 2-4. Did you examine it in the same fashion, swabbing the ends in the middle?
Yes, I did. Yes.
Is that a photograph of the band when you were examining it at the lab?
Yes, it is.
All right, that may be admitted.
And as far as the swabbings that you took of each of these 3 exercise bands, what did you do with the swabbings after you swabbed the items?
I allowed the swabs to air dry. I gave them each a item number, and then I preserved half of each of the swabs for additional testing in the DNA unit.
And did I hear you correctly that it was 5 months later that the state police investigators decided that you would get the shingles off the house?
I don't know when that decision was made, but that was the day that I was requested to go out.
And then the district attorney showed you the shingles and envelopes. You opened them up, looked at them, and you did a confirmatory test on those?
I did not. I performed a screening test on each of those stains at the scene. I did not perform a confirmatory test on those stains due to the fact that the red-brown stain color was no longer visible. So potentially
Degraded because of the weather, right?
at some point the red-brown stains appeared darker. They were no longer red-brown, so I thought that the material could be less, so I didn't want to use any additional material for confirmatory testing.
The next witness today, Jonathan O'Loughlin. He worked with state police in 2023 as a crime scene service trooper. He helped in documenting every room at the Clancy house and helped gather relevant items of evidence. He also processed the evidence to identify fingerprints. In cross-examination, Reddington once again brought up overlooked evidence by the state and local police.
And so, as it pertains to these items that you reviewed, the knife, the exercise bands, can you tell us what your findings were when it came to the knife?
Yes, the knife did have limited detail, meaning that there were areas of friction ridge impressions, which is referred. That's what we've referred to fingerprints. Is the friction ridge skin is the skin that covers your palms and your fingers and your toes and your feet. The friction ridge skin is what leaves the impression on an object. So there wasn't an area of friction ridge impression on that knife.
Mm-hmm.
So it was photographed further and giving an item number. Upon further analysis, there was not enough detail to do a comparison.
So when you photograph it for further analysis, why do you do that?
Do that in order to take a deeper look to see if there was enough characteristics or minutia to do a comparison to a known print.
So with a photograph, you can enhance it and look at it closer, correct?
Correct.
But after doing that, were you able to make any sort of opinions about that area on the knife?
Yes, there was not enough characteristics or minutia to do any comparison, so it was deemed no value.
And as far as the exercise bands, fair to say you also did the same and examined those to try to identify if they had any friction-rich detail or anything of value that you could conduct a comparison on, right?
Yes.
And was there any on either the yellow band, the black band, or the blue band?
No, there was not enough to do. Yes.
So you told us about your training. You told us about your experience. You told us about fingerprints. You told us how you seize items in the course of a search warrant. And then you told us about looking at the photographs and the items that would depict friction ridge, if any. But the bottom line is that you didn't get any fingerprints.
Correct.
And that you could have just said that, right? Just come on the witness stand and say, we didn't get any fingerprints.
It's a state.
So then you're talking about is the state police investigating this case. You guys walk around and you have cameras and you take pictures, right?
Yes.
That's what you told us about. But how about when you're executing a search warrant? Are you supposed to be thorough in the course of your search for items?
I don't search for items, sir. Everything I do is
right.
Yes, I document.
So if I went into the bedroom, I found a bunch of drugs, in addition to the drugs that were found in the kitchen, and I found these in a nightstand with blood on top of the nightstand and the knife that you talked about. You would have photographed that, right?
Yes.
We next heard from two toxicology scientists, and once again, Kevin Reddington told the judge, we have stipulated this. And even referred to the agreement that Lindsay signed this morning, that Lindsay Clancy signed, that the Commonwealth did not need to continue to call the chain of custody witnesses, but they kept it going, and the judge allowed them to. Even if you stipulate, I guess as a prosecuting attorney, you want to be careful. You want to be sure that the jury understands what's happening here and that you get it on the record. Because if you go to an appeals court and they're like, you didn't establish it, it jumped from here to here, what was up with that? At least they have their record. Hillary Griffiths was with the state police toxicology unit. She was testing whether there were drugs in Lindsay's system when she was taken into custody and which drugs were in her system when she was taken to the hospital. They took 4 vials of blood, 2 vials of serum plasma, 2 urine samples. So they had total 8 vials of blood, urine, and plasma. And they learned that prescription drugs were found in Lindsay Clancy's system.
What were the results in the testing of the benzodiazepines in the blood? The blood contained 8.8 nanograms per milliliter of diazepam and 20 nanograms per milliliter of nordiazepam and 4.8 nanograms per mil of oxazepam and 1.9 nanograms per mil of temazepam and 61 nanograms per mil of lorazepam. And in your role in this testing process, you're just running the equipment, running the tests, and getting the data, correct?
There is some analysis of the data. I have to ensure that the controls performed appropriately, that the instrument was running properly, and make a decision based on the instrument data, what I consider to be positive or not. But then it's handed off to another analyst who generates the final report.
And in this case, were all the controls appropriate, all the equipment running effectively, and everything done according to the policies and procedures of the lab?
Ultimately, all of the relevant controls that were associated with the samples performed appropriately.
And that detected mirtazapine, right?
Yes.
Lamotrigine, right?
Yes.
Probably mispronouncing this. Quetiapine?
Quetiapine.
And quetiapine metabolite, right?
Yes.
As well as trazodone, right?
Correct.
And just tell me, what is a metabolite? What does that mean, quetiapine metabolite?
When we consume drugs, our body will break down the drug often into another molecule before it's being excreted. And sometimes our testing can detect these breakdown molecules as well. So this test detected both quetiapine as well as its breakdown product.
So there was that would indicate that there was quetiapine that was in the blood, as well as a quetiapine metabolite or a breakdown over passage of time.
Yes.
Also, just you guys check for everything. There's no alcohol detected, right?
Correct.
No amphetamines detected, right?
Correct.
There was a benzo screen that was positive, which we've already talked about, correct?
Yes.
Buprenorphine screen, none detected, right?
Yes.
Cocaine and fentanyl, none, right?
Yes.
Methamphetamines, none, correct?
Yes.
Opiates, none.
Yes.
Cannabinoids, that'd be weed, right? None.
It's the active molecule in there.
Okay. Diazepam, none.
Yes.
Nordiazepam detected.
Correct.
Oxazepam detected.
Yes.
Teramazepam detected.
Yes.
Lorazepam detected, right?
Yes.
And then finally it says organic acids and neutrals, none detected, right?
Yes.
And then you talk about, that would be the acids. Then you talk about the actual organic bases, and it lists all of the other items that we just went through. Trazodone metabolite, for example. So you have the trazodone plus the breakdown of the metabolite. You have the mirtazapine as well as mirtazapine metabolite, right?
Correct.
Lamotrigine, quetiapine, and the quetiapine metabolite, right?
Correct.
Now, after this witness, it was time for lunch. Jurors went to lunch. Many of you have asked what Lindsay Clancy has for lunch. I'm not sure. I do know that in previous trials, I've covered Vallow and Chad Daybell, and they brought a sack lunch with them from the jail while their attorneys went out to eat. In fact, Lori Daybell's attorneys often walked across the street to a Winco and got pizza or something at the deli there. Well, they tried that the first few days, and then they got mobbed by the media, and they started to stay inside. I think they got a room in the courthouse and had food dropped off. Their client does not. I think once or twice, in Lori's case, they may have given her a Coke or some M&Ms. But Lindsay Clancy, I imagine they bring a lunch with her. It's not like they get a fancy meal, whereas the jurors often get food dropped off and brought in. Okay, so after lunch, the judge read the agreed stipulations to the jury regarding test results for the post-mortem reports on all three children, which means the defense doesn't have to dispute the conducting, analysis, or processing of evidence or DNA regarding these reports. Then Alicia Zimmerman, a state police forensic scientist, was called to the stand. She worked in the toxicology unit. She performs toxicology screenings on both adults and children. She did the toxicology reports for all three children back in 2023, starting with the blood and urine tests for Callan, determining whether or not he had any substances in his system.
Were any substances detected on those three screens and the pediatric screen that you've just described to the jury?
No, they were not.
And as far as the next case, which would be laboratory number 23-01875, the decedent being Cora Clancy, you received some heart blood from the medical examiner's office post-mortem, correct?
Yes.
And as far as that, were those screening tests conducted in this case for Cora?
Yes.
And were there any substances detected?
No, we did not detect anything.
And as far as laboratory number 23-01874, which is the decedent Dawson Clancy, your unit received an item 1-101 of heart blood from Dawson Clancy, correct?
Yes.
And that was also post-mortem?
Yes.
And were those screening tests, those same three tests plus the pediatric test run for Dawson?
Correct.
Were any substances detected?
No, they were not.
And so where in each one of these three separate cases there was no detection of any substances, did you do anything further other than issue a report saying none detected?
No. I reviewed the data and then I issued the report with the non-detected results.
If there had been any positive findings, additional testing would have been conducted, correct?
Yes, if we receive a positive screen, we will either perform confirmatory analysis or quantitative analysis depending on the testing.
And just as it pertains to these three cases, the samples received for Callan Clancy, why did they come from a different source than the other two?
So the medical examiner sends us the samples. If the decedent is in the hospital prior to the autopsy, they will typically send us those hospital samples as well. They prefer to have the hospital samples tested because that date and time is usually prior to the decedent's death, and we can sometimes determine what sort of drugs or poisons may have been in that decedent's body prior to their death and before drugs may have been given at the hospital.
Next, we heard from Sherry Kronk. She's a supervisor at the state crime lab. She specializes in blood spatter analysis at crime scenes to indicate the direction, patterns, transfer stains, drip stains, and tracing of the blood patterns. She reviewed images of the blood patterns in the Clancy's basement and master bedroom. Listen.
And is this from the master bedroom floor between the mirror and the bed?
It is.
Okay. And what did you learn from your analysis of this item?
So from my analysis in looking at the stains, there's a couple of different things going on here. So they're the round circular stains, which are on the outside, are drip stains. So that is blood coming from a bloodletting event and going to the ground just due to gravity. The stains that are overlapping are considered a drip pattern. So standing there for a period of time, the blood is dripping due to gravity into itself, causing the overlapping stains as well as the small stains that are all surrounding it. Over here on the right side, there is some movement through the some of the red-brown stains, causing them to have lateral determination, and so those would be smear stains. So they're originally drip stains that were smeared through.
And showing you E13 from your notes, is this a close-up of that same area?
It is.
Now, the bedroom window that Lindsay Clancy jumped out of had bloodstains that were deemed irregular in shape, and it was classified as a transfer stain. On the nightstand in the bedroom, where the knife was left, those were drip stains due to the gravity. The linear stains near the knife is a transfer stain from the knife itself. The stains on the floor of the master's bedroom entrance was determined to be drip stains on the floor. Got all that? there was a lot of blood. Patrick Clancy testified of that it was like a fire hose of blood in the room. And they had to determine where this blood came from and what the patterns showed. Now, there was a little bit of debate concerning the shingles, the window shingles in the courtroom, whether Lindsay was hanging off of the ledge outside the window and slid down the shingles, transferring it all the way down, or whether she leaped out of the window. Defense says she leaped. Prosecution said there's some question there that she may have been hanging. That I don't know if that was ever really resolved, but she was found at the bottom of the window. And yesterday we heard from all the witnesses who said she had her back, her spine was broken, was severed. There was not enough stains or patterns on the blood as far as that's concerned to determine exactly which one was accurate. Whether she jumped, maybe she jumped and grabbed on, or maybe she climbed and slid down. Regardless, she was found there. The jury was then excused for the day. Tomorrow, the Commonwealth will pick up with blood spatter analysis.
Okay, so that summary actually came from East Side News. They're pretty good to listen to. But if you decide that you would rather have me go through the complete trial and it just record the testimonies, the complete testimonies, let me know and I will go ahead and do that. Before I stopped recording, he did say, or after I stopped recording, I should say, I believe today is going to be a half day for them. So we'll try to get that uploaded either later today or tomorrow. We'll see about that. But thanks for joining me, and we will talk soon, guys. All right. Bye. Have a good day.